Students, welcome to the virtual class of Indian Constitution. So today let us discuss about the judiciary, which is a part of the union government. After legislature and executive, it is another important branch of the union government. So let us discuss the composition of Supreme Court of India. First, introduction. A strong and independent judiciary is indispensable to the success of a federal political system. The Indian federalism is characterized by the distribution of powers between the center and the states. In order to highlight the spirit of federalism, the Constitution of India has distributed the state powers between the center and the state governments. The distribution of powers is clearly specified in the written form. The disputes are bound to arise with respect to the distribution of powers between the center and the states. So, in order to decide these disputes, an independent and impartial judiciary is required. The result of the fulfillment of this requirement is the establishment of the Supreme Court. The Supreme Court of India exercises the ultimate powers pertaining to the interpretation of the Constitution and to settle disputes between the center and the state governments and the states interse. The Supreme Court of India functions not only as the federal court but also, according to Aristotle, as the protector of the fundamental rights. The Supreme Court is also the highest appellate court of the entire nation. It also gives its suggestions with respect to the issues of public importance when the President seeks them. Composition of the Supreme Court. The Supreme Court of India is the apex level court, the final court of appeal in India. The Constitution, under its Article 124, provides there shall be a Supreme Court of India. It enjoys supreme judicial authority in India. The Supreme Court is situated at the top of the Indian judicial hierarchy and has far more powers than any Supreme Court of any nation. It has jurisdiction over entire country and it can have judicial control over all the courts functioning within the territory of India. It is the final court of appeal in all civil, criminal, and constitutional cases. It is also function as the protector and custodian of the fundamental rights. One of its major functions includes the resolving of disputes arising between the center and the state governments. The future development and growth of the Indian Constitution rests on the Supreme Court. The Supreme Court of India came to be established on 26th January 1950 along with the Constitution of India. The power to determine the number of judges is given to the Parliament by the Constitution, Article 124. Therefore, the number of judges keeps varying from time to time. Initially, it had 8 judges, which went up to 11 in 1956, 14 in 1960, 18 in 1978, 26 in 1986, and 31 in 2008. The latest development in the judicial field is that there is a recommendation to increase the number of judges of the Supreme Court from 31 to 35. Types of courts in India. The top court or the apex court in India is the Supreme Court. So, next to the Supreme Court, there are many high courts working in different states. Then, below high courts, district courts, sessions court, and sub courts. After that, magistrate court. Next to magistrate court, special court. So, after that, family issue court, village courts, economic courts. So, these are some of the important courts working in India. So, this is the building of the Supreme Court of India, so which is situated in New Delhi, which is called as the highest court of the Indian Republic. Appointment of judges. Article 124 of the Constitution deals with the appointment of the judges to the Supreme Court. The Chief Justice of India is appointed by the President. Other judges of the Supreme Court are appointed by the President in consultation with the Chief Justice. He also consults other judges of the Supreme Court and High Courts while appointing them. The present Chief Justice of India is Ranjan Gogoi. He is the 45th Chief Justice of India since January 1950. Appointment of an acting Chief Justice. In case of office of the Chief Justice falls vacant, when the Chief Justice may be unable to perform his duties due to absence or otherwise, the President can appoint an acting Chief Justice. Qualifications to become a judge of the Supreme Court. Qualifications required for the appointment of judges to the Supreme Court are any citizen of India who has been a judge of a high court for at least 5 years, or who has been a practicing advocate in any high court for a period of 10 years, or, in the opinion of the President, is an eminent jurist, can be nominated or appointed as a judge of the Supreme Court. Article 124, Section 3 of the Constitution. Salary and allowances to the judges of the Supreme Court. As per January 30th, 2018 revised scale, the salary of the judges of the Supreme Court rised 200%. The Chief Justice of India draws a monthly salary of rupees 2,80,000. Other judges of the Supreme Court are entitled to draw a monthly salary of rupees 2,50,000. So these salaries are drawn from the Consolidated Fund of India. The judges are also eligible for official residence, free of rent, traveling allowance, medical facility, telephone facility, etc. Tenure of office. The judges of the Supreme Court continue to hold office till they attain the age of 65 years, but they can tender their resignations under their hand before the expiration of their term of office. So these are the judges since independence to till date who uh, completed their terms as the judges of the chief justices of the Supreme Court of India. Removal of the judges. The Parliament can remove a judge of the Supreme Court with the support of two-thirds members of both the houses of the Parliament on the grounds of misconduct or inefficiency. Judges can be removed by impeachment. Article 124, Section 40 lays down that a judge of the Supreme Court can be removed from his office by an order of the President. Such an order can be passed by the President only when an address passed by two houses of the Parliament by a majority of total membership and two-thirds majority of members present and voting in each house of each house is presented to him. Powers and functions of the Supreme Court. The Indian Supreme Court functions as the guardian of the Constitution, custodian of the rights of the citizens, the protector of the Indian federal system. The important functions of the Supreme Court are classified into different categories. So we can see the image or picture of the Supreme Court building, so which is looking like a crab. First function of the Supreme Court is the savior of federation. The Indian political system is a federal one and has dual governments, and powers are distributed between the center and the state governments. Disputes relating to their administrative jurisdiction are bound to crop up. The Supreme Court is given original jurisdiction to resolve these disputes. In the absence of the Supreme Court, the center and the states would be in constant conflict, and the federal system will collapse. The Supreme Court is also function as the protector of the Constitution. The Constitution is above the general laws. The Supreme Court works as its protector. If any law made or ordinances issued by the center or the state governments are in violation of the Constitution, the Supreme Court can declare such a law or ordinance as unconstitutional. This power of the Supreme Court is called judicial review. This also checks the Prime Minister and the Parliament from behaving dictatorially. Third function of the Supreme Court, it is the guardian of the rights of the people. The Indian Constitution has granted a number of fundamental rights to the citizens. In order to protect the fundamental rights and to prevent their contravention, the Supreme Court can use the constitutional safeguards such as the writ of habeas corpus, mandamus, quo warranto, injunction, and certiorari. Another function of the Supreme Court is it assists the growth of the Constitution. The Supreme Court makes the growth and development of the Constitution possible. By giving interpretations to the Constitution from time to time, the Supreme Court has made the Constitution to move with times. The Supreme Court uses its power of judicial review to bring about necessary changes in the Constitution in order to suit the demands of the changing times. A fifth function of the Supreme Court is final appellate court. The Supreme Court is the final appellate court in the nation. It receives appeals against the verdicts of the high courts and reinvestigates such cases. All disputes cannot be appealed to the Supreme Court because its powers to review the decided cases is limited. But the opinion of the Supreme Court regarding the legal interpretation is the final one. Sixth function of the Supreme Court is it is the court of records. Article 129 has made the Supreme Court to be the court of records. The records preserved by the Supreme Court have the value of evidence. If a particular court is declared as the court of records by law, the power to punish those who violate its verdicts also follows. Seventh function of the Supreme Court is Supreme Court functions to formulate rules and regulations. The Supreme Court, with the consent of the President and in conformity with the laws of the Parliament, can formulate rules and regulations to monitor its activities and functions. And it also functions as the advisory body. So, when the President seeks the advice and suggestion from the Supreme Court regarding legal or constitutional matters, the Supreme Court duly provides them, but the advice is not binding upon the President. Ninth function of the Supreme Court is enforcement of decisions. The Supreme Court has the power to enforce its decisions on the person's consent. It can also punish any person for contempt of court, which means disobedience or disrespect for a court of law. Then, 10th function of the Supreme Court is judicial review. Being the protector of the Constitution, the Supreme Court has the power of judicial review. If any law of the central or the state governments are found to be in violation of the Constitution, the Supreme Court can declare such a law as unconstitutional and stop it from coming into force. Such power of the Supreme Court is called judicial review. The judicial review not only includes the law of the central and state governments but also holds good to the orders issued by the state executives. So, these are the important powers and functions of the Supreme Court. So, I will conclude here. So, let us continue the other topic of the Supreme Court in the next class. Thank you.